Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to break down a brand new federal ruling issued yesterday that blocked President Trump's attempt to federalize and deploy the Oregon National Guard to Portland, Oregon, and why any end run like deploying the California National Guard to Portland instead would still be unlawful and likely to infuriate the judge. If you caught episode 45, we walked through the tight legal limits on using the U.S. military within the United States. The analysis necessitates a review of the Posse Comitatus Act, the Insurrection Act, and especially 10 United States Code, section 12406, which narrowly allows federalizing state guard units only for purposes of repelling invasion, rebellion, or when, quote, regular forces are unable to execute federal law. That framework is exactly what this Oregon ruling applies. President Trump appointed U.S. District Judge Karen Immergut of the U.S. District Court for the District of Oregon granted a temporary restraining order, TRO, on October 4th, 2025, yesterday, halting the federalization and deployment of 200 Oregon National Guard troops to Portland. First, we'll review 10 United States Code, section 12406, subsection 3, inability to execute laws. The Trump administration leaned on section 12406, subsection 3, to argue that troops were deployed because the administration alleged that protests made it impossible for the federal government to enforce federal laws due to the protests on the ground in Portland. The judge said the facts on the ground did not support it. In late September, Portland protests around the ICE facility there were small, mostly peaceful, and handled by Federal Protective Service and the Portland Police Bureau. Routine, sporadic issues were well within civilian law enforcement capacity. The judge essentially said if law enforcement can handle it as they did, the president cannot escalate to using the military. This situation was not a we can't execute the laws. It was at most we'd like it to be easier, which does not arise to a permissible level to employ troops under the statute as prescribed by the U.S. Congress. Second, we turn to 10 United States Code, section 12406, subsection 2, rebellion. The court read rebellion narrowly, consistent with history and sister cases, which must include armed, organized, open resistance against the government itself, not scattered misconduct around a single facility. The events in Portland did not even come close to a rebellion. Therefore, it was impermissible to attempt to activate the Guard under these circumstances. Third, presidential rhetoric does not equal emergency. The court flagged the president's overheated posts on Truth Social about the situation on the ground in Portland versus the minimal activity Portland actually saw, concluding the determination that troop deployment in Portland was necessary, quote, was not conceived in good faith in the face of an emergency and directly related to quelling it. Translation: you need real, concrete facts, not memes or month-old incidents that didn't even occur in Portland to justify troop deployment there. Fourth, the 10th Amendment of the U.S. Constitution. Because Congress, not the president, decides when the Guard can be federalized, and it did so only through 10 United States Code, section 12406, predicates blowing past those limits tramples on state sovereignty because the president is attempting to federalize the Oregon National Guard while it is under the authority of the state of Oregon and when there is no valid basis rooted in statute or the U.S. Constitution to permit the president to federalize the Oregon National Guard under these circumstances. The bottom line of the ruling: President Trump's attempted federalization of the Oregon National Guard was ultra vires, meaning outside of statutory authority, and unconstitutional. The court put the TRO in place through October 18, 2025, while the lawsuit filed against President Trump, Secretary of Defense Pete Hegseth, and Secretary of Homeland Security Kristi Noem by the state of Oregon and the city of Portland. You may be asking yourself, didn't President Trump order 300 California National Guard members to deploy to Oregon today, Sunday, October 5th, 2025, the day after the judge's order? Yes, he actually did that. As you likely assumed, swapping Oregon National Guard for California Guard does not magically create a legal justification for essentially the same actions. No predicate situation is created by swapping one state's guard for another in this particular scenario, nor could I see that being valid in any other scenario that I can conceive of at this time. The state of Oregon and the city of Portland filed an amended lawsuit today, this time along with the state of California, seeking a second temporary restraining order to also block the California Guard's illegal federalization and deployment to Oregon by President Trump in what appears to be an attempt to sidestep the judge's order. Oregon Attorney General Dan Rayfield stated, "What was unlawful with the Oregon National Guard is unlawful with the California National Guard. The judge's order was not some minor procedural point for the president to work around like my 14-year-old does when he doesn't like my answers." Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.